7-DM. This is the matter of Danelle Keys versus Michael Condra. This is the date and time set for a hearing on plaintiff's objection to first order modifying judgment of divorce. Both parties have appeared today via Zoom. There being no objections. And Ms. Keys, I will go ahead and get started with your presentation. This is your objection. Ms. Keys, what is your objection today?
There's a history that goes into all of this, but the specific objection today is we this summer started to look at revising our original support agreement as well as our child custody agreement. And we came to some agreements, but not all. We did mediation in September. And in August, one of the things that we had where we were making significant changes to the amount of overnights they would have with their father. So going from about 120 down to 60 or 70. So because one of the things we were not coming to an agreement about was our support calculation and all of that. In September, I issued, because it had been over 3 years since we'd had that support formula done, I sent something to the friend of the court and they did a new support formula going off of the incomes that we both had at this time. But what they did is they kept in that initial, what our first order, the overnights. So they had 120 overnights, but what we were looking at and had come to an agreement on as far as the overnights going forward, they'd be closer to 60 or 70. So my objection is to how that came back. It did not have the right number of overnights. But I will say in the time since then, when we went through this whole process, I found out about the whole state of Michigan site that you could go into and plug all those numbers in. So since we had all that from this new support calculation, all of his and my current numbers, we plugged them in. I sent that information to Mike, and he and I came to an agreement on November 30th of what all these changes would be, including the financials. So we came to an agreement. He asked me to type it up. I typed it up. I contacted the friend of the court to figure out what I actually needed to do to be able to make these changes official. And they said to just type it all up, have us both sign the paperwork and either fax it or drop it off to the friend of the court. So on December 12th, I had it typed up and signed on my end. I live in Tennessee, so I emailed it to Mike and asked him to fax it or take it to the friend of the court. So that's where we're at. He responded that he hadn't been able to do that yet. And so that's why we're still here. So I don't know how much we need to go into since we're at an agreement or how we go about at this point making those changes, but that's basically where we're at.
Okay. Thank you. So, Mr. Condra, what are you thinking at this point, based on what Ms. Keys just said?
So, no, I agree with all of that. And really, the reason I haven't signed this is I'm not certain. I guess my hindering block is I would like to see whatever the final of her notes is in the official paperwork before I sign anything. So we're working with two different rulings here, the judgment of divorce and also the custody, which don't mesh up with some of the notes in here. So, for example, I don't know if you have any of this paperwork in front of you, but the addendum that she has presented to the court and signed, there's a section 6 says omit. And I see that in the judgment of divorce, that's something that I've actually asked for. Future relocation. So kudos. However, in the order resolving child issues, section 6, joint parental authority. The parties shall continue to exercise joint parental authority and responsibility for health, et cetera, et cetera. I do not want to omit that. So do you see my trepidation I want to make sure that the paperwork is what is in my mind as to what we have worked so very hard to achieve before I sign it. Because one clerk's interpretation of her notes lands me with no joint parental authority just because I didn't do my due diligence. So that's really where we're at.
Ms. Keys, are you willing to include that joint parental authority language?
Well, and yes, because what I'm going off of, that section 6 that I said omit, was what he said initially, where he asked me to omit anything about future relocation because he clearly does not plan to ever relocate in the future. So that's where I'm not sure where Mike's getting the information or what he's talking about,
well,
but I understand what he's saying. If that's if there's different.
It says right here, addendum to CJOD and final USCO. It's at the top of the paperwork that she has signed. And I just want to clarify what form these changes are going on. She's working off of the judgment of divorce. I don't want to see these changes end up on the USCO in the wrong spot.
So are you saying that you would like to just kind of get a clean copy?
I would like a clean, yes, exactly. I would like someone in a legal department to write this up so that I know what I'm signing instead of speculating on what some clerk is going to put into the final after I've already signed it.
So you want something that lays out exactly everything, right?
Yes, sir. I have the original.
All right.
I would like the 2.0 of what I'm signing.
Is that doable for you to type up, Ms. Keys?
Well, I have typed this up. So I'm a little confused as to what he's actually looking at, because I did go off of and I'm not sure if what he's talking about by the two different documents. I did go off of that original or that final, and that's where I'm looking at these sections, and very clearly I kind of put out like section blah, 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 blah. This is what we want to change. So if what I need to do is now type up the 30-page document with each word, I'm not sure. That's what I mean, what I'm saying is I thought I did this pretty clearly of saying what this was. Well, I guess if I need to put in section 6, omit what section 6 was, absolutely, I can do that. That's not a big deal. But is there anything else that you have questions about? I guess I'd say that before I went into taking our original legal document, you know what I mean, retyping the whole thing, because what we did do, I thought, was pretty clear. If that's the only thing that's not clear, I can put in what section 6, what, you know what I mean, what it said.
That sounds like what he's saying.
That's
okay.
Yeah.
That's
I don't like loose language on some legal document that I'm signing.
Sure.
Is that the only question that you have? I guess because where I'm saying is, I mean, this again is like whatever it is, a 30-page document. I want to make sure you're not saying that I'm to type the entire 30-page document, but that's the one thing you have a question about. I can put in there what section 6 said on the document that we're referring to and what we're talking about omitting.
Well, I guess I just don't understand. Is this piece of paper that I'm signing just going in the file, and that's just the addendum to this? That's going to leave a lot of speculation in the future as to where. I just don't understand this whole process, I guess. Like, after this is filed, am I going to get a new copy of this anyway, Judge? Your Honor?
I don't, my confusion is that I'm not looking at the documents that you're referring to. So are those available to me somehow?
And I'm sorry, I do apologize, because I thought that we had all this issue sent out, and that's why I didn't know, because he said to cancel the court date, we have an agreement. And that's why I didn't present any of this stuff until yesterday, when I realized that he wasn't going to sign this. So it was all emailed to the court, but yesterday. And then
okay, well, let me see if I can find that.
Oh, and it came back to me that Stacey Osborne was out. So then I emailed it to just that 13th District Court, all of these documents. and that's where I wasn't sure what the process was either. And that's why the friend of the clerk told me, just type up what your changes are, just the changes, not the whole document, type up the changes, sign that and send it to us. And then I assumed that then they go through the process of making those changes. But
All right, so let me share what I'm looking at. Okay. Screen sharing this document that was submitted by Ms. Keys. I don't know if anybody can see that. I'll try and enlarge it.
I can see it.
Okay, so
And
that's email to Stacy Osborne. Okay, and so here we go. Addendum to CJOD and final USCO filed 10/12/2020. Okay, and so Ms. Keys, is this supposed to be the modification document?
yes.
Okay, so Part 2, Section 3(1), school year parenting time, fall break, Section C. Okay, so you're referring to the judgment of divorce, and I'm assuming in the judgment of divorce it has a Part 2, Section 3, subsection 1.
Yes.
Okay, and it's pointing out certain sections. So fall break. Father shall have the fall break every even year. Is that a difference from what's in the judgment of divorce?
Yes. Everything on here are
Yes.
the changes.
Okay. Everything on here are the changes. So scrolling down.
So it needs to be shuffled into the old form.
Well, no, not if this document specifically states that all other provisions not modified will remain in full force and effect. You understand that, Mr. Condra?
I do, but that brings me back to the separate order fully resolving child-related issues, which is
Am I looking at that? Is that a different document I need to
it's
look
a completely different. So when we got
at?
divorced,
Well,
I
I don't want
received.
to, please stop. I want to look at that document. How do I look at that document?
I don't think that you have this one,
That's not going to
probably.
be helpful for me.
But so I guess, but when a divorce is finalized, is the one I'm talking about, like that final, which is what got sent to me after everything was finalized. That's what I'm going off of. Isn't that's what the document we use? You know what I'm saying? Like, I know initially, probably, and through this whole process, there's several that
Yeah,
kind of,
that's the only document that has legal significance. Mr. Condra, are you referring to an order that was entered prior to your divorce?
Yes.
That's no longer legally significant. The only thing that controls your custody and parenting time and child support is your judgment of divorce document.
Okay, so that's the missing link in what my misunderstanding, because I didn't want this document to be floating out here in the nether without the changes made that are clear on the addendum to this one.
The only thing that's controlling anything right now is the judgment of divorce.
Okay.
So where does that leave us?
Well, all that I would like then would be a clean copy of the changes shuffled into this so that it's concise, and then I'm fine.
So and so by this, are you referring to the document that I'm looking at right now?
So I would like
Okay. So
the
section 6, it
consent.
says omit.
Correct.
So you don't want section 6 omitted. Is that what I'm to understand?
No, I'm fine with that. I just wanted to make sure that it wasn't the section 6 on the order fully resolving child-related issues.
You need to tear that document up. That's just
I know that. Well, I'm just getting back to the root.
Yeah.
I didn't want that to be mistaken for this.
No.
So that's where I'm seeing now.
Okay, let's tear that one up.
Okay. So yeah, other than a clean copy, I'm fine with this. I mean, we've pounded these out over months. It's not like I'm not going to agree.
Can I adjourn this hearing then to see if you two can get this accomplished?
so well, I guess, Mike, what I'm asking you is, do you understand that I can't exactly just go into that document and cut and paste? That's not the process. So you're asking me to retype like 30 pages with this in it. This is, I mean, I can, like, when we went through this originally, we were kind of highlighting and making that. So is that what you're, Because to me, this is giving them all the information.
If you would be so gracious to, I don't know what to I don't know what to tell you.
So that, I mean, from my perspective, that is really unnecessary.
Yeah,
What you would want is maybe just something in this addendum that says all other provisions of the judgment of divorce will remain in full force and effect.
Okay.
That short sentence will accomplish the exact same thing legally as retyping the entire judgment.
And
perfect.
that's not a problem. I can do that and then add that to it, sign it again, resend it to you. One thing I would ask, because I had you said you agreed to this on November 30th. I sent it to you as you asked it, typed up with a signature to send in, and it still wasn't filed, but never did you let me know that you had any problems with it until today. So I guess I just want some assurance that once we're done with court today, you will in a timely manner take this forward and do your part and get it signed and get it turned in as well.
Yes.
Your Honor, can you say that to me one more time? All other provisions of the judgment of divorce.
Not otherwise modified
Okay.
herein shall
Okay.
remain in full force and effect.
Okay. Thank you.
And what I can do is I can adjourn this hearing just to see what happens, and I can check in with both of you after a period of time and see what happened, and we can go from there. But it sounds like there's a good possibility you two might be able to work this out.
Okay.
Any questions, Ms. Keys?
No, thank you.
Any questions, Mr. Condra?
No, sir. Thank you.
All right, then. Best of luck. I'll adjourn this. You'll get a notice for a rescheduled hearing on this. And if you end up reaching an agreement, then you can let me know at that continuation hearing.
Okay, thank you.
Okay, thank you. That will conclude our hearing for today. Cassandra Sherman versus Max. Is it Galia, sir?
Galia.
Galia.
Yeah.
And this is a hearing on defendant's child support objection. Both parties have appeared today via Zoom, there being no objection. And Mr. Galia, this is your objection. So did you want to start with your testimony, or did you wish to call a witness? Are you able to hear me?
Yes. Yeah. Can you hear me okay?
It's a little garbled, but I think we'll be able to make it through.
Okay. All right. Yeah, I just want to say, I know I did put in a document stating, you know, what I wanted. I just wanted to reinforce that.
And
I've been
one moment, Mr. Galia. I'm just going to go ahead and swear you in before you provide.
So yeah, I've been, you know, taking fully taking care of Oliver for the past 7.5 years financially. You know, I've been taking him to, you know, all of this, you know, I've been putting him in his sporting events and you know, making sure he gets to all those things and everything like that. You know, buying him clothes and everything for school supplies and whatnot. And right now, as the current order stands, right now I have him about 70% of the time. Cassandra has him about 25 to 30% or so. So, and I know with the child support right now, it is going off of the last stage, which is 50, which is a week on, week off. Cassandra has been, lost my train of thought. But I've been taking care of Oliver. You know, it isn't cheap, you know, or easy taking care of child. I do have, I do provide for, a few other people in my household as well. So all of us paying this child support on top of still having Oliver 75% of the time has really put a damper on everything. He's in hockey, um, which isn't, isn't cheap.
Mark and Julia pay for that.
I haven't been getting much help.
Okay, just time out. So only one person can speak at a time. So right now it's Mr. Galia's turn. So Ms. Sherman, you'll have your opportunity. Go ahead, Mr. Galia.
Yeah, and because I haven't been able to get much help with any registration fees or anything like that from Kazan. But because I was getting the child support, but now instead of me receiving it, I have to pay it. So it's just really complicated things because the custody, it does not reflect what the child support is. And I would like that the child support, the formula reflect what it currently is until it gets to 50-50.
Anything else, Mr. Galia?
No, that's all.
Okay. And then did you wish to call any witnesses today?
Oh, yeah, I wanted to call Elizabeth Stelzer to, just reconfirm that, Lizzie is a core person in Oliver's life. She spends a lot of time with him. Make sure he gets to a lot of, she does a lot of the running around for his events and stuff like that. So I just, I wanted to give her a chance to speak.
Ms. Stelzer, so I mean, did you kind of get the gist of what Mr. Galia is asking you to weigh in on?
Yes.
All right, you may proceed.
Okay. Say my part right now.
You can say your part now.
Okay, yeah, thank you. Yeah, so like what Max was saying too, being a core person in Oliver's life, I am doing most of to school, from school events, signing up for camps, everything that Oliver essentially has going on. I am the person that signs him up, make sure that the forms are turned in, that the school projects are done, that he has his right gear for the Christmas concert. All of those things that you do as a parent, especially as a mother, I am doing all of those essential things, running to the store, appointments, like I said, all of those things. So, yeah, and that's just it, and it's not a problem at all. But yeah, again, we are doing that in Oliver's life constantly, and we love to do it, and I would choose to do it over and over again. But is what the case is about. It's about, the child support. And yeah, that is a main, because that is what we're doing. And making sure that he has his right winter gear, because if he doesn't have his, gloves for school, the school is calling me, the office is calling me to make sure that he has gloves for school, for boots for school, all of those things, to making sure that we are able to supply him for, and we do. So yeah. And yeah, Oliver's someone that he loves soccer, he loves hockey. And that's something that, my older son is in. Obviously, we all live together. I have an older one who's 9, and then I have a younger one who's 6, almost 7. Then Oliver falls right in the middle. So as you can imagine, all the boys are doing stuff together constantly, and it's a great time. We love it. But of course, when the older one is doing soccer, of course we sign up Oliver for soccer, and then so on with everything else. So Oliver's just tagging along with us, and we have a blast, and we love it, and he loves it. And again, we wouldn't change any of it, but that's where essentially we need that support, because Oliver is home with us 75% of the time. And again, we love that. We would choose that no matter what. But that does require we're doing everything. We want to give him everything.
Thank you. And Mr. Galia, was that basically what you were wanting Ms. Stelzer to speak to?
Yes.
Okay. And Ms. Sherman, you didn't have any questions for Ms. Stelzer, did you? Oh, I'm sorry, you're muted.
Yes, sorry about that. I would like to know if she's employed at anywhere.
Yeah, I work for my parents part-time doing work on their rentals.
Okay. Thank you, Ms. Stelzer. I'll go ahead and you can log off, but either way, I'll put your device back in the waiting room. Thank you.
Okay, thanks.
Okay. So then, one moment. Okay, so just to be clear, Mr. Galia, what are you asking for today?
Just that the child support reflect what is happening currently in the court order.
Okay.
So I did supply, I did do I did it online on Michigan case. I put it so I did do uh I did submit a form a formula. So
Okay. All right. So, well, thank you. And this is a case where defendant has filed a motion objecting to a child support order that was recently issued. A child support order was based on the parties sharing equal parenting time. The parenting time is a graduated schedule of parenting time. And Mr. Galia is asking today that child support be based on parenting time as it currently is, which is not equal, rather than what it will end up being at the end of the graduated schedule. At the end of that graduated schedule, basically, essentially, well, really starting next summer, it's going to go essentially to equal parenting time at that point. But it's not equal right now. And Mr. Galia is asking that child support be based on what it is now. However, the parties did reach an agreement at mediation. That mediation agreement is dated October 12th, 2023. It was memorialized in a fourth order, modifying order for custody, support, and parenting time, also entered on October 13th, 2023. That's the controlling order regarding parenting time, which resulted in the child support review in the first place. And that mediation agreement, which was incorporated as a court order, provides at paragraph 9, quote, child support will conform to the Grand Traverse Friend of the Court recommendation based on the end parenting time schedule, unquote. Obviously, in this case, the end parenting time schedule is the schedule that will provide for equal parenting time for both parties. So the agreement said explicitly right there in paragraph 9 that child support is to conform to the recommendation based on the end parenting time schedule. The end parenting time schedule is the equal parenting time schedule. That was clear, that was explicit. There's nothing confusing about that language. There's been no allegation today of any change in circumstances that would allow this court to modify that provision regarding child support. At this point, the court finds that this was really a frivolously filed objection. And frankly, I'm concerned that this objection was filed in light of, Mr. Galia, your written word provided to this court in October that you were going to agree to child support based on equal parenting time. So this is very unfortunate. Obviously, the objection is denied. Ms. Sherman, are you employed? I can't hear you. You're muted.
Yes, Your Honor, I am employed. Yes.
All right. And do you work today?
I do not work today.
Okay, you had today off?
I have all week off due to Christmas break. I have both my children with me.
Okay, then. All right. Well, it appearing that Ms. Sherman is not hasn't had to lose any wages as a result of having to defend against this frivolously filed objection, I'm not going to award any costs or fees today. But for the reasons stated, the defendant's objection is denied. I'll issue a referee recommendation and order submitted to the assigned judge to be signed. Either party may file an objection and have a de novo hearing, provided you file your objection within 21 days. That'll conclude our hearing.